Hi, this is James Bezan, your Member of Parliament for Selkirk-Interlake. Over the past number of years, people across the riding have told me that one of their top concerns these days is law and order. Too often, we see law-abiding citizens victimized in our towns and cities. In Selkirk-Interlake, I know of many cases where people have seen their property vandalized, stolen, or their persons threatened or harmed. I know that our justice system should be working for victims and not criminals who threaten our security and sense of law and order. Our government understands that, which is why we have introduced a record number of criminal justice reforms that will tilt the balance in favor of Canadians and make sure criminals are doing serious time for their actions. Of the most significant reforms we have introduced was Bill C-25, legislation that strictly limits the amount of credit granted for time served in custody prior to conviction and sentencing. In the past, criminals who are awaiting sentences were allowed to bank credits for time they served awaiting trial at a ratio of 2-to-1. This means that the criminal's actual sentence could be significantly reduced before they spent any time actually in a federal institution. By getting a 2-for-1 deal, the justice system was rewarding criminals whose trials took longer and offending victims who expected justice to be done. Our reforms will significantly reduce this practice and ensure that criminals who have a criminal record or violate bail are never able to bank these 2-for-1 credits. Our government was pleased to see the bill receive royal assent this February. It was widely supported by lawyers and justices across the country. According to Saskatchewan Minister of Justice Don Morgan, and he said, quote, "Canadian people are dismayed when they see criminal sentences reduced because of pre-trial remand credit. This legislation will help restore public confidence in the judicial system," end quote. Since then, we have introduced a landmark set of proposals that will continue to build on the success of Bill C-25. In March, we introduced amendments to the Young Offenders Act to strengthen its handling of violent and repeat young offenders. These amendments were entitled Sebastian's Law, in memory of Sebastien Lacasse. Sebastien was beaten and stabbed to death by a gang of young offenders in Lavelle, Quebec a number of years ago. Of the most important parts of the legislation is that it will require the Crown to consider seeking adult sentences for youth convicted of the most serious crimes: murder, attempted murder, manslaughter, and aggravated assault. It has been praised by victim groups and the Lacasse family who work tirelessly on behalf of the rights of victims. In April, we announced legislation to ensure serious time for the most serious crime, which would end the faint hope clause that allows murderers to obtain early parole. I think it is simply unacceptable that those who have the criminal intent to carry a serious murder should be able to get early parole. In particular, the bill will ensure that criminals who commit first-degree murder will not be eligible for parole until they serve the full 25 years of their sentence. Similarly, offenders serving life imprisonment for second-degree murder would no longer be eligible for parole until their parole ineligibility period is served. A very positive benefit of this reform is that the families of murdered victims will no longer have to suffer the anguish of attending repeated early parole eligibility hearings. Why should a mother of a slain child have to relive the experience of her loss by considering whether her child's killer should be set free? This is totally unacceptable, and these reforms will end this harsh practice. It is another positive step to put the rights of Canadian victims ahead of the rights of criminals. While these reforms are essential, the justice system should not also favor criminals who do serious crimes other than murder. That is why the minister introduced a bill to end house arrest for property and other serious crime just a few days ago, after the announcement of ending the faint hope clause. Currently, criminals who are convicted of serious property and violent offenses, including arson, fraud, counterfeiting, aggravated assault, human trafficking, luring a child, street racing causing death, and others, have been eligible to serve conditional sentences, including house arrest. Tell me how it is justified that a criminal who burnt down your house should be allowed to serve a portion of his sentence in the comfort of his or her own home. This bill will end that practice and is supported by police officers and victim groups right across the country. The president of the Canadian Police Association commented saying, and I quote, "Chronic and violent offenders rotate in and out of the correctional and judicial systems, creating a sense of frustration among police personnel and fostering uncertainty and fear in our communities. This is a positive step to address the revolving door justice system and instill meaningful and proportionate consequences for serious and violent crimes," end quote. The Canadian Resource Centre for Victims of Crime also supported this initiative, saying, and I quote, "Victims feel distressed when they see offenders, not only those responsible for their own victimization, but also those who commit other serious crimes sentenced to house arrest. This proposed change will address concerns that some victims and survivors of violent crime have expressed to our organization." End quote. These bills build on a number of other positive initiatives that we have introduced within the last month, including the introduction of the Combating Terrorism Act to provide police and prosecutors more resources to investigate terrorist activities, legislation to help protect children from online sexual exploitation by requiring suppliers of internet services to report online child pornography, legislation to tackle property crime, including auto theft and trafficking in property that is obtained by crime, by creating new offenses in the criminal code that involve these types of property crime. We've introduced tougher sentences for fraud and other types of white-collar crime by adding new aggravating factors that courts can consider while sentencing. We have legislation promoting tougher penalties for drug crimes, which will specifically target gangs and other organized criminal groups who participate in the illegal drug trade. So as you can see, these measures will tip the balance of our justice system back in favor of the victims of crime and not the criminals. For far too long, previous governments have attempted to soften the justice system for those who do serious crimes, creating a revolving door where criminals bank upon the loopholes and measures in the criminal code which provide them with the equivalent of a get-out-of-jail-free card. This is unacceptable, and I'm pleased that our government has introduced these measures to make sure that serious criminals do the time that they deserve. It upholds Canadians' inherent sense of justice and makes it clear that crime has real and not superficial consequences. I want to take a few minutes and talk about the gun registry. Now, as you know, my colleague Candace Hepner from Portage Lisgar has a private member's bill before the House of Commons, Bill C-391. This bill is currently at the committee stage, and it's going through the hearings at this point in time. There's been a lot of misinformation put out there. We've had a number of the leaders within the Police Association and the Police Chiefs Association appear before committee, and they're saying that this gun registry is something that they use every day. They're throwing out numbers like it's referenced 11,000 times a day. Now we have to remember that every time a police officer on the street runs a license plate, that they actually see that information automatically is directed into the gun registry. Whether they make use of that information or not is doubtful, but they do automatically register with the gun registry that they have done a search on this individual because of something as minor as pulling them over for not turning on a signal on a corner. More importantly, though, is that I believe it's also giving police officers maybe a false sense of security. I've heard from police officers who say that, yeah, they do reference the gun registry when they're going into, say, a home that they know there's a grow op or there might be somebody there that's peddling drugs. And when they go there, they actually do check the gun registry. Now, I don't believe that they should be changing the way they enter into any of those properties, knowing that the person that's in there is not registered with the gun registry. Of course not going to be. Criminals don't register their guns. And so they still have to go into those type of dangerous situations knowing that very well the individuals in there are going to have illegal firearms. More importantly, we want to make sure that we can quit this practice of penalizing law-abiding gun owners. Whether they're farmers, hunters, or sports enthusiasts, they deserve the opportunity to not have to register every firearm that they have in their possession. It's $2 billion that has been wasted. It's $2 billion that would be better spent in adding more resources to our police community to ensure that they have the tools that they need to do a job of protecting our citizenry. Also, we need to think about the illegal gun trade and putting in more officers at our borders to ensure that we catch those that are bringing over those illegal guns that are actually a revolving trade with our entire drug community. Often we see high quality drugs made and manufactured in Canada go down to the US and traded for illegal firearms that are then used in illicit crimes. Now, we've been hearing that Michael Ignatieff is going to be whipping his vote to ensure that every member of the Liberal caucus votes in favor of keeping the long gun registry. We believe that that is the wrong thing to do. Members of Parliament have to be able to vote their conscience, have to be able to represent their ridings, and the 12 Liberal members of Parliament from rural Canada have to be able to express the desire of their constituents in the House of Commons. But Agmagulagnadia is playing petty politics here and is trying to protect out-of-control bureaucracy that has not prevented one single gun crime. So we need to ensure that people continue to put pressure on those 12 Liberal MPs and that they come around and vote with their ridings and not with the Liberal Party. Well, that concludes my parliamentary update for today. If you have any thoughts, comments, or questions, any issue important to you, do not hesitate to contact my office. You can also visit our website at www.jamesbezan.com for updates including videos, press releases, and speeches. Thank you for your attention, and I look forward to joining you again.